afternoon, Namibia and the world, and welcome to our Wednesday edition here at the Government Information Center. My name is Desire Kahiha, and I am your host for the afternoon. And today we are looking at the functions of the Law Reform and Development Commission of Namibia. In the studio, I have two panelists who will be looking at answering the questions that we have and hopefully educating us about their work and their functions, their objectives, their visions, their missions, whatever it is that we need to be educated on so that we can get a bit closer to their offices and what they stand for. We do have Mr. Charles Wanga in the studio. He is the Chief Legal Officer with the Law Reform. Good afternoon, Mr. Charles.
Good afternoon.
And accompanying him, we have Mr. Matthias Kashindi. He is the Chief at the Law Reform. Good afternoon, sir.
Good afternoon.
Thank you very much for availing your time, and I do hope that by the end of this session, we will be experts, as are you. And I start very simple. I want to know, what is law reform?
Thank you very much first for the opportunity to have us here. As an introduction, I think it's a very important question. And in short, law reform is basically a slow but an in-depth process, including research on social aspect and legal aspect, and it involves also conducting consultation, workshops, and basically ensuring that public participation is involved so that the outcome of the process can guide the intended legislation or policy.
Okay. So basically it's the process of creating the policies of law, or how do we then just put it in one statement? Law reform.
It involves reviewing, reforming, and also developing the law.
Okay. Then we would then ask a bit of background, because we're talking about the Law Reform and Development Commission here. And a lot of people have heard about law reform. We've just given a definition thereof. Some of us, including ourselves, were not really familiar with it having a commission on its own. So maybe if you can give us a background on the establishment of the Law Reform and Development Commission and what its functions are.
The Law Reform and Development Commission is a creature of statute. It is created under Section 2 of the Law Reform and Development Commission Act 1991. However, the commission only became operational 2 years later because the law only became operational in 1992.
Okay.
So effectively, we can say the Law Reform and Development Commission has been in existence for 30 years.
Yeah.
The functions or the objects of the commission basically is to undertake research in connection with its objects, examine any branch of law, and to make recommendation for the reform and the development of the law. Now, that includes a lot of activities. One, for example, is recommending repeal of obsolete laws, laws that are no longer suitable for the current dispensation, for example.
Okay.
In Namibia, we mostly talk laws that are of apartheid origin and do no longer suit the current dispensation after independence. The consolidation of or codification of the law, the integration or harmonization of the law, also new or effective procedure for the administration of justice, for example. Those are in a kind of regulations or rules or some kind of, and then the enactment of laws to enhance the respect for human rights. That has to do with our obligation in terms of the constitution, and also in terms of the obligation that Namibia acquired because it became a member of international legal instruments.
Okay.
Just a few. But on top of that, the Commission can also consider any matter that has been referred to it by the Minister for consideration.
Okay. Okay. Now we have looked at these functions. We've established what they are, especially the four functions that are. But I'm now thinking to myself, what is the importance of these functions? Mr. Wanga, maybe you can help us with that.
Yes, yeah, thank you. So, like Mr. Kashindi said earlier, basically the Commission really looks at very broad areas of the law and try and investigate all those various areas of the law and see which maybe in coming up with a particular new legislation or in reviewing an existing legislation and so on. So, for example, when one of the objects says that the Commission will make recommendation for the repeal of obsolete laws or unnecessary enactments, one really looks at the current laws on our statute books, and you sort of look at, are certain laws in terms of the statute book still relevant? Are they perhaps outdated? Do they still serve the purpose that they were initially intended to serve? So the importance there is really to ensure that your statute books are really current and up to date, and you don't have unnecessary laws which don't really serve any purpose. So in that regard, for example, the Commission has in the recent past had a project specifically on obsolete laws.
Okay.
Because obsolete laws, it's an ongoing process. I mean, a law that you make today can become obsolete in the next 5 years if it no longer serves the purpose. But in terms of the projects that the Commission came up with, there were two phases. Phase one looked at about 55 laws on our statute books that were actually recommended by the Commission for repeal. And in fact, these laws have been repealed because there was a repeal law that repealed all these laws. Phase two then also continued to look into other laws. However, I think we are still in the process of getting those laws repealed. I think phase two identifies a total of about 33 laws on our statute books, which it proposes for repeal. And it's really because some of them are very outdated and no longer necessary. Some of them are based on apartheid, so you will have laws, for example, that speaks about certain groups of persons based on their color and so on. And therefore, there is no relevance really in the current constitutional dispensation to maintain such laws. So that is why it is important. When one looks at consolidation, you don't really change the law, so to say, but what you do is you might have a specific law that speaks to a certain subject, let's say divorce, for example. And then you have certain laws that speak about that particular subject, but they are sort of scattered. So what you want to do is then try and consolidate all the provisions or laws that speak to that subject so that you can have it under one law and make it more, easily readable and so on. So that is the importance of maybe in terms of consolidation. Integration and harmonization of customary law with common law. So customary law is a very important area of the law in Namibia, given the various cultural groups and different people from different cultural backgrounds practice, for example, their own customary laws. But then you also want to give it sort of the importance it deserves. So you want now, in terms of this objective, you want to harmonize customary law with common law, which is the law that Namibia has sort of inherited from before independence up to now. Because even in terms of Article 66 of the Namibian Constitution, provision is made to say that customary law and common law are sort of placed at the same level, and both of them should then comply with the statutory laws and also the constitution. So I think the importance is really to try and strike that balance, and also just to ensure that you bring along customary law and not leave it to die, and give it sort of that significance. Yes, so I really, that is sort of the importance of the various objectives that the Commission looks into whenever they embark on processes of developing or reforming laws and so on.
Okay.
Yes.
I stay with you, Mr. Wonga, and I want to find out, because you spoke about a very important element there, and I believe, if I understood correctly, you said it's the repeal of obsolete laws.
Yes.
And these, most of the time, are those that really focused more on apartheid rule and regulations. Now, if you say, for example, there's a law that deems it illegal for a black person to have or be found or own a can of beans, is there a time frame in which you as a commission are supposed to kind of go through these laws and either repeal them, change them where necessary, if need be? Some of them are still viable but just need to be changed in the way they are addressing the nation. Because I'm thinking 32 years after independence, understandably so, our constitution, as good as it is, it was one that had to be done or formulated under a very short time period. So one would really applaud our lawmakers back then. They were good, if you look at the number of days that they were given. But 32 years later, really, are we still having those?
Okay. Yes, so I just want to indicate that, look, because a law is old doesn't necessarily mean it's bad law. Trust me, we have laws that are dating back to 1909 or 19, but those laws are still good laws and they are still relevant. So when you look at obsolete laws, it's not necessarily because of the time when it was passed. But you look at the specific subject matter to say, is it still serving its current purpose? I'll give you one example, or a few examples from the report on obsolete laws, for example. There is a law that, in terms of the first phase of the obsolete laws project, there was a law on dry peas control ordinance. It's a 1957 law. So this law made it illegal for a black person to be in possession of peas, because at the time it was felt that maybe they would use this to fermentate and make alcohol or whatever the case is. So to have such a law is really, one, it's unconstitutional simply because it differentiates between persons because of your skin color and so on. And secondly, really, the purpose of it is maybe it was relevant at the time for the particular administrators, but it's not relevant at the moment. Yeah, so you asked the question that 32 years later, do we really, I mean, looking at some of these old laws that we still have. But remember, in terms of the Constitution, specifically Article 140, what we call the transitional provision, it provides that all laws on the date before independence will remain in force until that law is repealed or amended by an act of parliament. So yes, this is now just part of the process of trying to look into these laws and saying, okay, let us propose that they be repealed or amended because they no longer serve the purpose. Yes, you are right in terms of the process, because it's not an easy process. One, you need to really consult widely to ensure that whenever you now make a proposal for a law to be repealed, whether indeed that law has no real use at the moment. So it really, the process of consulting on this project, it took some time, but eventually it's because you want to ensure that whatever you propose to be repealed is really a law that is no longer of any use or purpose.
Yes, Mr. Kashindi?
I just want to underline, and in addition to what Charles has said, you see, that's why we are talking about phases. Phase one of obsolete laws was already done, and it has a list of so many laws that were repealed then. Then you come with phase two, I think if you remember 2 or 3 weeks ago, our minister has tabled in Parliament a report on obsolete law. That is phase 2, proposing the repeal of. So phase 3 is still to come. Now, what it involves, the whole process is, because once you identify a law that you think is obsolete, you need to consult the line ministry and give them the full legal position why you think is obsolete. If it's the ministry that has identified, they will then have to go a whole process of consultation from the Attorney General to everyone. And then once that is determined, you then have to go to your books of law and say, once we take out this law, are we not leaving a gap? So then you have to formulate the law that will cover that gap. Because if you just take it out, then that aspect in the society will be left unregulated, and that will create a problem. So you have to avoid leaving a lacuna, what in law, which is it's just a gap.
Yeah.
So that's why it takes longer. But I think in response to your question, to say 32 years, yes, reasonably, I think we have done relatively well, especially that we have phase 1 and phase 2 already gone. So we are looking at phase 3 now going down again, but this time you may not necessarily just be looking at very, very old laws, because as Charles indicated, laws that you may have passed 5 years ago, society has evolved and may no longer be suiting. Those ones may also become subjected to review and maybe become obsolete. Thank you.
Well, as I always say, it's a conversation here that we have at the Government Information Center, and you're always welcome to join the conversation. And you can do so via our social media platforms through which we are streaming our show. On Facebook, you can find us at Ministry of Information and Communication Technology, Republic of Namibia. That is Ministry of Information and Communication Technology, Republic of Namibia. You can also find us on our YouTube platform, and our handle there is MICT Namibia, MICT Namibia on YouTube. Later on, we will be opening up our lines where you can give us a call in the studio if you have a question for the panelists, or maybe just a comment where you would like to add your opinion to the matter. But while we wait for you on our social media platforms, I'd like to continue here by asking our panelists to take us through the stages of lawmaking. I think that whole process has, I believe from what I'm hearing now, has various stages that it has to be, that a law has to be taken through before we get to that law standing, if I can call it that in layman's terms. So maybe if you can just take us through that process from step 1.
Thank you. So we, in terms of the Law Reform and Development Commission, we have stages of the lawmaking process specific now to the work and mandate of the Commission. And those are the ones I'll quickly take you through, but also keeping in mind that in terms of there are also stages of lawmaking when you talk about now lawmaking in the Parliament and so on. So I'll take you through the stages for the Law Reform and Development Commission. So initially, what we start off with is the process of a project initiation document. So this is a document that will basically identify the issue which the Commission has picked up, or based on its own initiative, or whether it was as recommended from the public, or maybe from the line minister and so on. So this project initiation document is really will outline what the project is about, and basically what the issues are relating to the specific area of law. It's basically what we also called a project management document, basically. So it will outline your processes from the first stage until finalization of the particular project. After that, what we then do is we come up with what we call a development of an issue paper. So the issue paper is basically a document which identifies the number of issues that are involved or relevant to the particular concern. So let's say, for example, if you are if your chosen area of law is issues of maintenance, for example, you will then outline in your issue paper what are those issues regarding maintenance that you would be investigating in terms of that project. What you then do is, the next step would be that you will have consultations on the issue paper. So one of the main components of work for the commission is really the issue of consultation. And you will see in terms of the various steps of the law reform processes in the commission, there is a number of stages where there needs to be consultations, either with the specific targeted stakeholders or with the general public and so on. So you will then consult on your issue paper. The idea of that consultation is to sort of try and develop your issues, hear from the stakeholders or affected persons what other issues are involved and so on. And then you then work towards, based on the consultation, you will then develop what we call a working paper, or also what we call a discussion paper. So this is more a beefed up document from the issue paper. So it will have more research, for example, on the issues. It will have more inputs from other stakeholders and so on. And then from there, you then workshop it. So you go back to the public consultations or stakeholder consultation. Now with a working document to say, based on the earlier consultations and further research and so on, this is what we have come up with. Comparative studies also with other jurisdictions, then you present that to the stakeholders. And then normally you may also at that stage produce what we call a layman's draft. So already just to give an indication of how the law would possibly look like at the end of the process. Once you do that, you may also then have specific consultations on the draft itself, on the law. So again, that's another stage where you need to consult various stakeholders, the public, and then after that only, you then prepare what we call a final project report, and then that project report will now outline all the processes you have undertaken, and it will give recommendations of the recommendations by the Commission to say, this is what the Commission recommends should be done in terms of this particular area of the law. And in terms of the Act, these reports are normally submitted by the Commission to the Minister of Justice for the Minister's consideration, and further, the Minister will then decide how to proceed further with that report. So that is really, in a nutshell, in terms of the lawmaking or law reform process of the Commission. Yes.
Okay. But in your experience, I would actually like to find out, because clearly that sounds like a lot of steps.
Yes.
And one would understand why there are so many, because as Mr. Kashandi here said earlier on, you don't want to leave a loophole. What do you call it? A lacuna.
Yes.
I'm learning new terminologies here. When I get out of here, I'll be an expert linguistically. So you don't want to leave a lacuna anywhere. So understandably, there are a lot of steps that are involved. But from your experience, what has been the average time period from step one all the way through to the last?
Yes, that's a very good question. So like Mr. Kashindi said earlier, the law reform process is a slow and in-depth process. So yes, so some projects, maybe they are not as complex. So you would be able to finish a project, and some of them don't necessarily have to follow the entire process depending on how they came to the Commission. Maybe they came at the Commission at a very advanced stage. So you would only need to maybe have one or two other consultations, and then you will have a final report. So from the first stage to the last, I tell you, it's not easy to say how long it will take. It can take months, it can take a year, it can take years. So for example, if you look at the number of reports that the Commission has produced since its inception, it can be objective or subjective, because I think we have about 44, 45 reports now at the moment. But these are also on very important subjects and very technical subjects. And some of them have really translated into very important legislation. We talk about the Combating of Rape Act, the Maintenance Act, the Marital Equality Act, electoral transformation of Polytechnic to NAST, all this. So it's, like I said, it's subjective, or it can be objective, depending on how you look at it. But it's really not easy to say exactly how long it will take.
Okay, let me rephrase that question then. Since inception, from your experience, from your knowledge of the various reports, what's the longest time period?
That's another good question. Yeah, so, yeah. I think you could, some of the projects I personally, for example, had to do, took almost 5 years. And that is a process of back and forth. Sometimes you finalize the final report, but then there's further inputs that is required, and you have to revisit the project. Some of the projects that we have produced, we had to also, at the stage of submitting to the minister, it's referred back, and you have to sort of go back and relook into certain areas of interest and so on. So, yeah, 5 years, personally, that's what I can maybe say, but it's because of really the kind of projects, I mean, laws, the number of laws that you need to look at, almost something similar to the obsolete laws project. So it's not to say, for example, that we are only at phase 2 now, that we have not looked at other obsolete laws in the past. But I think in the past 5 years, that's when we said, let's take these obsolete laws approach in phases, where we do a assessment of a number of laws, and then in one wholesale amendment, you then repeal those laws.
Okay, okay. I'm deliberate in asking these questions because we tend to sit, you know, in our couches at home, and we are, you know, I'm not trying to, you know, take sides here, but it's the honest truth, where we find ourselves sitting in our homes and couches, and we are, you know, badgering the lawmakers, as in, why is it taking so long for them to do A, B, C, D? Why have they not established this and this and this law? But sometimes when you have a platform like this, this is where you get the opportunity to give an idea of how long something might take, which you know, us, because we don't know the processes, we are not, you know, experts in the various fields, we think it's something that can be done in a month or two, while we are unaware of the various offices and processes and steps, the back and forths that you referred to, that, you know, this particular thing has to be taken through, just to make sure that we solidify and it doesn't come back to bite us in the bum in the future. As we said, you can give us your comments and questions on our social media platforms, and we have one. And this one comes from Dilimeke Liatate, and this is on Facebook. And Dilimeke wants to know, are those projects same as bills tabled in National Assembly? Are those projects same as bills tabled in National Assembly? Simple as that. There's that question. Mr. Kashindi, maybe you can assist us with that one.
Thank you very much, and I appreciate the question from the caller. It's yes and no.
Okay.
Because the project may be initiated, but may result in no bill being tabled in the National Assembly. But if a project has been initiated and it goes through all the stage and approval has been granted, and then it becomes the bill that is being tabled in the National Assembly.
Okay.
Yes.
So it's the forework, a forework for the bill, basically. That's
yes.
what the project
yes.
is.
In fact, let me just maybe re-emphasize our role. So our role in the lawmaking is the secretariat to the commission. So the commission role is basically the initial stage of before everything goes to cabinet and parliament. So the Law Reform and Development Commission does the initial research, compilation of the report and an accompanying bill. So then the other institution will come in and say, no, law reform, you have done well, we are fine, we can proceed. But it may come back again, and sometimes, even before you go to Parliament, an important question related to a specific aspect in the bill comes from the public. And the process may be sent back to say, there has been an omission here, we are not seeing this aspect addressed in the bill, it's very important, and therefore, researcher law reform, please again do the job. Okay. That's why I'm using the word is yes and back and no.
Okay.
Yes.
Yes, Mr. Vanka, you want to add to that?
Yeah. I just want to add that also the Law Reform and Development Commission is not the only institution that initiates a particular law. In fact, there is no mandatory provision that requires all laws to pass through the commission in order to be passed. So you would have laws, for example, Parliament can, the National Assembly on its own, they have their own lawmaking process where they table a particular issue, it becomes a bill, and then they pass it and it becomes an act. We also have line ministries that can, for example, initiate that process of amending a particular law that they administer in Parliament directly without necessarily coming to the Law Reform Commission. So there are various law reform initiatives by various institutions, and the Commission is not necessarily in that position where we are the gatekeepers of all law reform initiative. Of course, maybe that could be something that can be considered in future, but at the moment, unfortunately, that's not. And I think Mr. Kashindi will also probably later talk on the lawmaking process in broader terms, apart from what takes place in terms of the work of the Commission, but also the lawmaking process nationally in terms of Parliament and so on.
Okay.
Just to explain maybe how a bill or probably a law really makes its way until it becomes an act of Parliament.
I was getting worried there for a minute because it's not risky to not have a gatekeeper, to not have a gatekeeper for something as important as this, because now you've got all these functions and projects going on all over the place. And from my understanding, to have a commission like the Law Reform Commission, it's one that allows for the thorough investigation and research and so on. So isn't it maybe safer? I won't say to consolidate. They can still carry on, but have at least one gate where it passes out and we say, okay, good, we've looked at everything, we can now continue. And it also just brings everything, how do you call it? It brings everything together, where you at least have one place where it's filtered and it's confirmed and affirmed and so on. But then again, I'm not the expert. I'm just looking at it from a layman's perspective. And you as well, from the street, you're welcome. Whether you are also an expert in the field, whether you are just wanting to find out something with regards to law reform and specifically also the commission in itself, you can call us in the studio. And our number here is 061, that's the area code for the Commerce region. The number is 400397. 400397. That's the number here in the studio. And again, you're reminded that you can also post your questions and your comments on our social media platforms. On Facebook, we are at Ministry of Information and Communication Technology, Republic of Namibia. That is Ministry of Information and Communication Technology, Republic of Namibia. We're also live streaming through our YouTube platform, and our handle there is MICT Namibia. MICT Namibia. While we wait for you to join our conversation, we continue here with our next question, and this basically speaks to what happens once the commission is done with its project. Mr. Kashindi.
Thank you very much. Once the commission has finalized the project, it compiles a report together with the accompanying legislation, what we call the layman very layman draft. Then the reports in terms of Section 9 of the Act is handed over. No, before it's been handed over, the report is being printed and being published. Once published, the report is then submitted to the Minister of Justice. The minister may agree with all the recommendation, may not agree with all the recommendation. Once the minister is satisfied, the minister will then table the report before cabinet. Once cabinet has been consulted and is in agreement, the report can then be tabled by the same minister in parliament. And then parliament take over. They have their own process there. I don't want to go into there because it's not represented here. Yes. But I also want to emphasize on the point that we, regarding the no mandatory provision for the kind of gatekeeper. So the current legislation does not make it mandatory that any person or any institution who want to initiate a law reform project must come through the law reform. But there are certain guidelines documentation that are in place. And recently, Cabinet made it mandatory that institution or whoever want to make a law reform project initiative must comply with those one. So briefly, I can.
But before you give us those,
yes.
Pardon me, Mr. Kashindi, we have got a caller on the line.
Okay.
I'll get back to those particular mandatory regulations.
Yes.
Mr. Emmanuel from Okakarara, good afternoon. How are you?
I'm doing well, and yourself?
Very well. How would you like to add to the conversation this afternoon?
I just wanted to find out why does it take so long, even with simple amendments, amendment to a provision or to the Criminal Procedure Act, for example, 51 of 1977. This is the South African Act which we are still using, and in South Africa itself, it has been amended several times. They are almost sitting with a new Criminal Procedure Act now, and we are still using it without any of those amendments. And ours was mooted already in 2004 up to today. Why does it take so long? Even Proclamation 15 of 1928, for example, it is still on our statute books, and the people up there in the north, they are still suffering because of this proclamation of 1928, 32 years after independence. Our people are still suffering because of these provisions of that Proclamation 15 of 1928. And there has been a discussion about new divorce laws and that the regional court might entertain divorces and so on. It has been coming since independence. Do these people even have capacity, or what's going on? Why does it take ages and ages? And it has been reported in some cases that people are sitting in unhappy marriages because of these stringent conditions before you divorce and so on. That's why there was proposal that magistrates court or regional courts, for that matter, should be dealing with these things. But still up to today, we are just sitting there. This process, from this process, this one and this one. Do we have capacity to make the necessary changes?
Okay.
That's my contribution.
Okay.
Thank you.
Thank you very much, Emmanuel. He's calling us from Okakarara. I'll definitely hand this question over to our panelists.
All right. Thank you.
Thank you. Who wants to take the ball?
Yeah, I can go first.
Okay.
Yeah. Emmanuel, thank you very much for your question. I really sympathize with you. I'm equally a citizen of this country, so in one way, I may also be affect you. So I think the caller has a very valid point, but looking at the question, we may not have been privy to the full answer to that question, because as far as we are concerned, all these projects that he's talking about, they have passed our institution.
Okay.
We have done our work, we have researched, we have compiled reports with the initial draft legislation, and they have gone to the next stage. I think they get stuck somewhere, and now I'm not certain which one came back, for example, to ask to redo the work. But as explained earlier, it's a length process and very slowly because it requires full public consultation. I can understand, for example, Proclamation number 15 of 1920, which in layman I can say is the red line marriages.
Yeah.
So there are certain aspects that require consensus in society. Because if you take it and you pass the law that is not really supported in some areas, then it may affect, because you are trying to say you want a one regime for all matrimony in Namibia, because now you have a dual. But if you just do it quickly, it may not result in the desired outcome. I think in short, that is my answer. And I just re-emphasize that most of these projects, they have passed the Law Reform and Development Commission processes. And they are being attended to somewhere else. Maybe there is where the delay is. But I understand and I sympathize with the caller.
Okay. Hopefully, yes, Mr. Wanga.
Maybe also just to add, like Mr. Kashindi correctly said, some of these projects are really, I think at the stage where they are now, we call it after-sale service. So the Commission has reports and finalized and submitted already. So, but then of course when you transmit it to the next stage, there is still some sort of assistance that we provide in order to see through that this particular recommended piece of law can actually go through the length and get passed into a particular law. So I think that is really the stage at which it is. But the public is also open to visit our websites in order to see some of those reports that we have already published and the types of recommendations that are made in those reports. I think for the Criminal Procedure Act, that's a very interesting read. I think there is quite a number of literature on why exactly that law could not be passed because of a lot of issues regarding constitutionality of provisions and so on. And I think that is really where it sort of got stuck immediately from the tracks. And one can always really read up on those aspects. Because the idea was to try and sort of repeal the entire Criminal Procedure Act of 1977 and have a new Criminal Procedure Act. And so in the absence of that, we still use the old Criminal Procedure Act. But there is also a lot of case laws which have dealt with specific sections of that act and have actually come up with either declaring certain sections unconstitutional and so on. So like I say, sometimes the law, the fact that it's old does not necessarily mean it's bad law. That's...
I think the law is it's a living document. That's always what I call it.
Exactly.
It evolves, it flows, it stays fluid.
And sorry, just also to add, some of the laws that are being proposed also come with a lot of implications in terms of financial and you need to set up institutions, you need personnel. So whenever, as much as the text is okay, there is that aspect of financial implications, and you have to set up institutions in order to make sure that the law is implementable as soon as it is passed into law.
Okay. Mr. Kashindi, you were about to educate us on a few regulations there that were newly implemented. Please.
Yes. What I was alluding to is to say the process is guided by some guideline documents. In addition to the Law Reform and Development Act, which established the commission, so we have some policy document which guides the law reform or the law-making process. For example, there is a cabinet directives of 93, I'm sorry, which set the procedure to be followed for when a ministry or agency or whoever want to come up with a law. So it's, for example, it say before anything you must consult the Office of the Attorney General and then so that the Attorney General can pronounce himself on the constitutionality of the envisaged measure and whether those measures cannot be effected by other means or administrative means, so forth. And then it says after that consultation, you get the opinion of the Attorney General, then it set the next stage, then Cabinet, Committee on Legislation, certification, and then until to Parliament.
Okay.
So then there is another decision of Cabinet, which involves the National Planning Commission. So it's the decision number 13/2816/004 on the National Planning Commission guideline for the structure of a public policy document. So this one outlined how a public policy document must contain.
Yeah.
So that whoever is interested in coming up with a law reform initiative, he must follow that guidelines. The other one is on guideline for public policy making process in Namibia. It also outlined what are the processes that must be involved. And then there is now the recent one, which was passed, I think, a few years ago, which now make it mandatory for ministries or institutions that comes up with, who want to make a policy document. They make it mandatory to follow the lawmaking process that are outlined in the document that I already initiated. So in a way, it's not really a gatekeeper, but it says wherever you are and you want to, because at the end, these documents are going to go either to Cabinet if it's a policy document, or if they are law, they are going to go to the national, to Parliament. And say, for that document to reach here and be considered to be proper for consideration by the National Assembly, it must have complied with all these guidelines.
Okay.
Yes.
So it's not necessarily that we have one particular institution that is acting as a gatekeeper, but we've got guidelines, mandatory, by the way, mandatory guidelines that are standing in for that, institution. They are the gatekeepers.
Yeah.
Okay. Time is not always on our side, but we would like to take another question on our Facebook platform, I believe. We have a question there. And again, we've got Ms. Dilimeke Liatate. Thank you very much for your involvement this afternoon, Ms. Dilimeke. And her question is, are you researching sodomy law, the sodomy law of 1929? Ms. Dilimeke wants to find out, is there research being done on the sodomy law of 1929?
You want to take it?
Yes. Yes. So basically, the commission in 2021 embarked on a project where specifically looked into this particular sodomy law, and there is actually a report with recommendations on that subject matter. So we are not actually doing it, but we have actually done it already.
Okay.
And there is a report available and published on the issue of sodomy.
That came out in 2021?
Yeah, that was last year.
Okay, last year?
Yes.
Okay. Okay. So, Dilimeke, I hope that you have your answer. And I believe the commission has a website, maybe, where people can look at some of these reports that have been completed that are, out there that a person can maybe read or people have interest in.
Our website is currently not fully active. We are in the process of trying to activate it.
Yeah.
So but the reports can be found. We have a small library at our office.
Okay.
Member of the public, I
welcome.
think, are welcome to approach us if they want the report, and we can avail it.
Okay.
Yes.
Okay. Very good. We'll find a way and a solution where there is a problem. So while they are setting up their website, they have availed a library for all their reports, and the public, if interested, can just approach their offices and documents and reports will be made available. Besides that, how else can the public access your offices? What other contact details are available to the public that they can maybe approach somebody if they've got a question, or maybe they've read one of these reports and they've got, you know, a position? Yeah.
Thank you. It's a very important question. Our stakeholders, they need to know where we are. We are currently hosted on floor number 8, Sanlam Center,
Okay.
Independence Avenue. Our telephone number is 061 233 194. Alternatively, 061 230008. Email, you can email the secretary to the Law Reform and Development Commission, which is myself.
Okay.
matthias.kashindi@mog.gov.gna.
Wow. Matthias.kashindi
At mog.gov, yes, .na.
Okay.
Yes.
So these are the possible contact details that you can utilize if you've got any questions, as we said, with regards to any of the reports, or maybe just in general, if you want to find out about what they do at the Reform and Development Commission. But just to leave us with an idea of some of the work that you've been busy with, most recent, what are some of these projects? Just give me two, top of your head, quickly.
Okay, so I think most recent in the past 5 years, we have developed quite a number of projects, reports on projects. We have a project on administrative justice. So administrative justice basically is a very important project because it deals with the aspects of especially public officials exercising their powers and in terms of the legislation, covering things like fairness and so on. So that's one of the projects that we have, or reports that we have produced recently. We also have the project on the so-called red line issue. So this project, the matrimonial property regime project, makes proposal for sort of having one uniformed marital regime for the entire country and to do away with this red line and dual. We also have a project on laws impeding development. This is one of those ongoing projects of the Commission, but that project specifically zooms into the issue of housing and urban land.
Okay.
So it looks at a number of laws that the Commission makes recommendations for repeal or amendment in order to address some of the challenges that speak to or on the issue of housing or promote or increase access to housing and urban land. Yeah, there are quite a number, but
okay.
those,
No, we just wanted a few examples just to indicate there exactly what it is that the Commission is busy with, and especially in more recent days that people can connect with. 30 seconds. Closing remarks, Mr. Kashindi.
Thank you very much. We are busy with quite a number of projects. I will not go into detail. I can just mention a few. There was, for example, one project on small courts project, which it looks at facilitating a creation of small courts to deal with small issues instead of these expensive other things.
Yeah.
I think that is one of the projects. We are also dealing with the child justice project. It's currently in its almost done, so it's one of them. Charles, can you remember another one?
yeah, I think those are the most.
Yeah.
The child justice is actually a policy. The idea there is to propose for a child justice system so that you have children who come into conflict with the law dealt with separately from the formal criminal justice system. So it's quite an important project. And the small claims court, like Mr. Kanshidi said, is really to facilitate access to justice for people that have small claims against each other. And then you don't need to pay a lawyer to get to this expensive procedure in the courts, high court or magistrate courts. Because those are some of the important projects.
Okay.
I have now borrowed from his 30 seconds. I'll quickly exhaust mine.
Okay.
Yes, so I think I just, as a takeaway, really to say that in terms of the Act, the public there's a provision for the public to make recommendations to the Commission, for the Commission to embark on projects or specific issues or laws that the public thinks that the Commission must attend to. Okay. So the details that we have shared, the public is obviously welcome to always visit and make their recommendations so that we ensure that it's part of our program. And then lastly, also just to say, apart from the Commission not being a gatekeeper for all law reform initiatives, I think the work of the Commission is really, in terms of the in-depth, is what attracts a lot of our OMAs to actually approach us, because they at least know that once the Commission embarks on a project, they would really have gone and dig deep into the issues. Okay. And whatever the proposed outcome is normally something that is well researched and so on.
Okay, okay. With that, we have run out of time. These discussions always need a lot of time, and it's never on our side. But again, just a reminder, as Mr. Wanga said there, the public is welcome to always approach the Commission, especially if they've got recommendation or request, and the addresses there and contact details have been shared earlier on. They are on the 8th floor of Sanlam Building. You can call them 061 233 194, alternatively 061 2300008. You can also email the Secretariat to the Commission, and that is Mr. Matthias, and his email address is matthias.kashindi@mog.gov.na. At this point, I thank you very much for being part of this conversation. I thank my panelists for availing their time to come and explain, what the Commission does, and also just enlighten us on the processes that different laws and projects go through. From myself, Desire Kahiha, and my production crew, it's bye-bye.